your host, Gary Austin.
Hi, this is attorney Gary Austin, back in our series of videos giving tips and guidance in divorce, family law cases, child custody cases that'll help you moving forward. Today, I wanted to discuss judges and decision making. And recently, I've been in court. These are comments from two judges. One essentially told the courtroom, lying, dishonesty goes on in court every day, despite the fact that you give an oath, tell the truth. And I think that's just more human nature than anything else. There are disagreements. Some people lie. It's a fact of life. A second judge that I actually recently had a successful case with said when she became a judge, a family law judge, she was very surprised about how limited her powers are to do things in cases. And this talk today is really to give you a sense of what you can do given that there may be disagreement, dishonesty, and the limitations of a judge's power. So what I tend to tell clients is let's get into court and try and move the ball as far as we can, move the case forward in the direction that they're seeking, understanding that you will be attacked, that there may be misrepresentations made, and it's still important to keep moving and knowing that the court can only do something or some limited thing. So recently it was in court, as I mentioned before, the same judge who mentioned their limited powers, and we did a pretty good job of laying out the facts, which if you've listened to or heard some of my prior videos, clear facts are very important. We laid out some pretty clear facts that my client had been acting appropriately towards the child, despite a prior contempt case being brought against him to say he had been violating court orders. So much so that when the judge saw the information, and the big thing was bringing a child to an exchange location where the child was reluctant to go with the other parent. The other parent saw contempt, but they dismissed that. Then they sought sole legal and sole physical custody. Because we were so clear in what we presented to the judge, again, acknowledging their limited powers, first thing out of the judge's mouth is, your request, meaning the other party's request for sole legal and sole physical custody, is off the table. And giving some more information to the judge to make it clear that what my client had been doing was in the child's best interest, the conversation shifted completely to, now, what are we going to do for the child? And most of those questions then went to the other party about opposing what was in the child's best interest. So even in a limited situation in which there had been dishonesty, there had been a limitation on what the judge could do, just moving things a short way, giving the judge some idea of what our actions were, again, bringing the child to exchange points, communicating with the other party despite their non-communication, and showing really that it was the child didn't want to deal with the other parent, as opposed to our client withholding the child, meant a lot, because this child is now, custody was changed. The child is now with my client. The child is now back in school because there was a prior joint custody order that mom would not agree to. So showing just small bits of evidence gives the court the power to act where it needs to. And now, even more important, there was a limitation placed on the other parent that was not previously there, just by clear evidence, concise evidence, and honest testimony about what's going on. That's what you want to provide in each one of your cases, even in the face of another party being dishonest about what's going on. Recently, I had another custody case, where my client was perjury. The other side said my client was committing perjury in a case that clearly could have gone the other way. We provided some evidence that showed the client had been honest about what was going on. There was claims that the parent had allowed the child to be abused by another significant other, and some allegations of substance abuse. Still, once we were able to put forward some information that showed that there was a kind of a mountain out of a molehill situation, despite threats from the other party that my client committed perjury, and even a statement by a judge that if they find out my client is being dishonest, custody could be flipped and the child sent to another state. But it was at the end of the hearing, the judge, after the party, my client had been interviewed, the child had been interviewed, said this is essentially a disagreement over an Xbox. child had been sent out of state but came back to California. And now, because my client had done a little bit more, the father of her newborn, which I didn't mention, but there's a newborn, who was kicked out of the home, now has the opportunity to get back into a child's life in a way that's meaningful, despite a lot of mountain out of molehill, the sky is falling arguments from the other side. So at the end of the day, what these two cases illustrate are the need to be clear, to be credible, and to be convincing. And despite lies, despite limitation on court's powers, if you have those three things, you can move the ball towards you and likely get custody of your child. You can move the scenario in a way where you get expanded custody time if you are doing what's in the best interest of the child. Now, if you have an issue similar to this and you'd like to see if we can work together or in alignment, please reach out to our office. Let's see about helping you with your family law matter.